Let me preface my discussion with picking up two themes, not in the way you intended the themes to be picked up, on discourse and smoking. I'm a regular cigar smoker, and I often smoke in St. James's with a group of people. And every time I light up my Paul Laranaga Petit Corona, there's an individual there who keeps on challenging me about the free market and what a mess the liberal philosophy, liberal economics, whatever you want to call it, has created for the Western world. And I keep on pointing out to him that you can't equate classical liberalism with existing capitalist economies. He doesn't accept that, and we endlessly have discussions, and he's a bit of a stirrer, so it just keeps on going on and on and on, and sometimes destroys my smoking. But the point of that anecdote, if it is an anecdote, is that recently I've been reading a lot of books that have been coming out on neoliberalism, and particularly I did a review recently of Stiglitz' Road to Freedom. The title's not particularly original because it parodies Hayek's Road to Serfdom, but he picks up that things. He says that Hayek and Friedman are responsible for the ills of capitalist economies, that they have endorsed the ideas of Hayek and Friedman, which are basically they are advocates of the unfettered markets, that they are the best self-regulating protections for consumers and workers, and they maximize economic growth. He says that this is just bad economics. Most markets are inefficient, exploit workers and customers, and are based on property laws that favor big business. And Hayek is accused of advocating what I would call lawless markets, that is, markets without any law or regulation, and the program of deregulation, privatization, and liberalization have rolled back the state. And he even goes as far as to accuse Hayek of being a precursor of the road to fascism, which is a pretty extreme example, which I think says a lot about Stiglitz rather than Hayek. Now, the problem here is that this myth of neoliberalism, which has huge traction at the moment, I'd make 2 points. One, this idea of unfettered markets. I mean, Hayek wrote 2 books setting out the legal foundations of the free market. And his last work was actually called Law, Legislation and Liberty, which doesn't quite indicate that there's no law in a competitive market situation. And he also said, and I think it's been emphasized by Jeremy, that the range of variety of government action that is, at least in principle, reconcilable with a free system is considerable. So among some liberals, Hayek is considered as a big government advocate, and I think von Mises walked out of the first Montpellier Society accusing him of various things. But the paradox of this neoliberal myth is that at the same time people describing the growth of neoliberalism, the state has got larger and larger and larger. So there's a paradox here, or a myth, that's being propagated. I think after the Second World War, in particular, the state spiked, and the 2020 pandemic, it spiked. And even in the United States, after the 1930 Depression, the growth of government has been unrelenting, even though these sort of neoliberal views were being holding sway. And this is even during the Reagan administration, during the Thatcher administration. Privatization led to regulation. The role of the state transformed into a regulatory state and a social welfare state. And of course, when you look wider, which a lot of economists don't sometimes, is if they are industrial economists and looking at law and economics, they don't appreciate the impact that monetary policy has had on the growth of the state. There's an interesting book by Sharma, What Went Wrong with Capitalism, and says that the modern state is just addicted to constant intervention and support, extending the safety net not only to individuals who are in need, but also to large corporations and banks. And this loose monetary policy is socializing risks, making each downturn less, but exacerbating the next downturn, and is smothering capitalism. So there we have the sort of present-day context of, I think, what has been described here as the discourse, saying that liberalism has created a problem, yet the tenets of liberalism are not being adhered to in terms of the growth of the state. The state has got a different dynamic to this sort of intellectual debate about what is neoliberalism or not. Now let's then come to Hayek. Hayek, you may disagree with this, really spent, since the Road to Freedom in 1947, 45 actually, 44, because it's the 80th anniversary of Hayek's Road to Freedom, as it is the 50th of his Nobel Prize. When he wrote the book, Keynes wrote a review of the book, which was very complimentary. But he said one thing about the book, which I think Hayek took very seriously and spent the rest of his life trying to deal with. He said, "This is all very well. I agree more or less with what you've said. I think it's a brilliant book, but you have not told us where to draw the line between the state and the market." And I think Hayek devoted a lot of his time, both in the Constitution of Liberty and the law, and his subsequent work, into trying to draw that line between the state and the market and to give some general principles. And he also said, which is, I suppose, picking up the theme of this conference, in his inaugural Mont Pelerin Society speech or talk or lecture, unless we can provide some guidance about what are the legitimate or necessary government activities and what are its limits, we must not complain if our views are not taken seriously when we oppose other kinds of less justified planning in inverted commas. And his broad answer to this, which was picked up by Jeremy in his masterful overview of Hayek's life, intellectual life at least, his answer was, in broad principle, the rule of law. I should like to propose that we should regard the infringement of equality before the law as the best definition of government interference. Whether productive government actions which can be carried out by laying down a general rule applying to all people and at all times are desirable or not is a matter of expediency, but that government measures which involve discrimination between different people, the application of different rules to different people, are objectionable at all times and should be ruled out altogether, appears to me a matter of general principle. And so he attempted to use the rule of law, or the German version, Rechtsstaat, or whatever it is, but in my view, quite ill-defined, because I've read a lot of Hayek, and I still haven't got a handle of what the rule of law is in his view, because as common lawyers would take the rule of law as equality before the law, and of course that tenet itself doesn't stop. You can say that all certain types of people should be shot. If it's applied equally amongst all the population, then that satisfies the rule of law. Obviously, he meant more than that, and he's been heavily criticised by some, particularly Anglo-British lawyers, of not really understanding what the rule of law is. But he obviously had a Germanic definition of the rule of law, which one day I'll have to speak to some German lawyers to find out exactly what that is, because there's a substantive rule of law and a procedural rule of law. But he's not very clear in any of his writings what he actually means, and I think he changes from time to time. But just to put into, not context, but to give what I think is the central idea of a lot of Hayek's work on markets and government, is that we all know, and it's been described by Jeremy, that the central proposition is the importance of knowledge and the knowledge problem, that central planners don't have the knowledge to orchestrate the market in a way that can even begin to replicate the way the market system works. This knowledge is a localized understanding of particular circumstances of time and place, to quote Hayek, only known to each individual and dispersed among individuals. And it's not the same as the economics of information. It's something quite different. He viewed the competition as a discovery procedure, we've been told that, and creating a spontaneous order. But what is less appreciated is his case for the market, liberalism, and economic freedom is not based on ethical presumptions, but irremediable ignorance. He says, and I'm quoting here from something in, I've got the wrong date here, but the awareness of our irremediable ignorance of most of what is known to somebody is the chief basis for the argument for liberty. This is especially true in the economic field. If it appears that the market mechanism leads to the effective utilization of more knowledge than any directing agency can possess, this is the chief foundation of the case for economic freedom. And Hayek went as far, in perhaps a sentence he probably doesn't want quoted too much, he said, if men are omniscient, there will be little case for liberty. From an economic point of view, the application of this to market analysis is that he flipped over causality in markets. When you get an economist in front of you, they will say, well, a free market or a perfectly competitive market requires perfect information and rationality. Hayek said it's the other way around. Competitive markets are not based on the assumptions of perfect information and economic rationality. Competition is efficient because it generates information and knowledge, makes it necessary for people to act rationally to maintain themselves, and firms to maximize profits if they are to survive. So those assumptions are really the outcomes of the market system. So what did Hayek actually say about a liberal view of regulation and competition? Well, post-Montpellier society, they replaced laissez-faire with competition as the litmus for this form of liberalism, together with a permanent and adaptable legal framework and the rule of law. As we know, Hayek proposed very active state intervention or involvement with the usual things from Adam Smith, National Defense Administration Justice, uniform taxation to finance public goods, a sound monetary system, and later he moved to competitive currencies. He advocated an extensive system of social services, so long as the organisation of these services are not designed in a way that affect the competition. He was an advocate of means-tested guaranteed income scheme and compulsory social insurance. Most of this was not because of a central concern about the needy, but also to protect the market system, because if people don't insure themselves and don't take care, they become a burden on society, and the state then intervenes. His approach post-1944 was really what could be called the law and economics approach, but different from the Chicago approach. He stressed that the efficiency of competition depends above all on the existence of an appropriate legal system, which must be intelligently designed and consciously adjusted. And this may be a hostage of fortune for those who believe in small regulation, because continuously designed and intelligently designed and continuously adjusted, and I think he also used the word planned, can open up the thin edge of the wedge, which he accepts. The minute he said there should be regulation, he's opening up the thin edge of the wedge to more and more regulation. The appropriate legal system has several key features. Obviously, private property, freedom of contract, but not unconstrained private property and freedom of contract. The state must put some controls, because obviously the exercise of property rights is a reciprocal thing. You may exercise your property rights which affect the property rights of someone else, and so there must be some resolution to that. The Coase theorem is an example of acknowledgement of reciprocality of property rights. He distinguishes, as already been said, between grown law that evolves over time in a sort of competitive process, and made law imposed by Parliament or regulation. And he, I think, was influenced by Leone to adopt, well, from a legal point of view, he made an important distinction that law is not just that handed down by the state. It evolves through custom and tradition and precedent. And he was quite enamored about the common law, and said the common law, I think he got a bit carried away sometimes, was the law of liberty. But then he backtracked and said, well, the common law can go on a trajectory as it evolves that is not consistent with liberal principles. And he actually says that the common law, English common law, was over-influenced by landlords and employers during the Industrial Revolution to go in a particular direction, and over-egged freedom of contract over freedom to trade. And so he, like Adam Smith, as he alleged, saw that the state could legitimately interfere in the common law to put it back on the right trajectory. No one knows how the state knows what the right trajectory is, but one of his important contributions, at least from a legal point of view, a legal jurisprudential, legal philosophy point of view, was he revitalized the notion of the rule of law. And the rule of law for him, as I've quoted before, but is basically that the rule of law should consist of general abstract rules, universally applied, and this would limit the coercive powers of the state, and is a method of distinguishing liberal from illiberal regulations. I'm not too sure about that. What was his view of the state? Getting carried away here. He had essentially a utilitarian view of the state. He advocated considerable regulation, health and safety regulation, building regulation, certification of professions, restrictions on the sale of arms, explosives and poisons and drugs, regulations for the processes of production and provision of such public institutions as theatres, sports and sports grounds. I mean, setting weights and measures, standards, surveying land and registration statistics, and went on. And this was in 1947, before the Montpellier Society, so you can imagine how some people walked out. Or von Mises wasn't too amused by all this. He also asserted that the state should have far-reaching discretionary powers. And the appropriateness of these discretionary powers should be judged by what he called whether the benefits exceed the costs, but basically cost-benefit analysis, and be subject to judicial review. And in some instances, he exempted the state from the rule of law completely. This previous point he called expediency. He exempted the state from the rule of law where it concerned national security, internal insurrection, natural disasters such as storms, floods, earthquakes, epidemic of avalanches, spread of contagious disease, and fires. The state could intervene without complying with the rule of law. Seems to be the case for Donald Trump. And he compulsorily supported universal military conscription because it was consistent with the rule of law. If it was compulsory and universal, it was non-discriminatory. And I think if you read through Hayek, there's a lot of overemphasis of non-discriminatory rules. I mean, in the area that I spend most of my time at the moment in competition law, antitrust, if you read Hayek there, he was against price discrimination. And to be fair to him, it was price discrimination which was exclusionary, trying to exclude, which we would call predatory pricing at the moment. But of course, price discrimination is consistent with the market economy, and the Robinson-Patman Act in the United States was banning price discrimination to protect small corner shops from larger, not supermarkets, but larger stores. So there's a big tension there about his application of non-discriminatory regulation and his view about even basic economics as to how he would deal with it. This all stems from the rule of law because, as I've said, he's put that on top of his whole conceptual system. And as I've also already said, it's very hard to get a handle on what he means by the rule of law. In 1960, in the Constitution of Liberty, he describes it as a meta-legal doctrine or political ideal. And then earlier on in 43, an article called The Rule of Law, he says, stripped of all its technicalities, this means the government in all its actions is bound by rules fixed and announced beforehand, rules which make it possible to foresee with fair certainty how the authority will use its coercive powers in given circumstances, and to plan one's individual affairs on the basis of this knowledge. And then later, going back to his 1960s, he says the rule of law has three attributes: generality, equality, and certainty. And basically, there's general abstract rules universally applied in a non-discriminatory fashion. I think you can see from the open-ended nature of those definitions that the rule of law can be compatible with quite coercive, and I mean, he sometimes even reneges on the non-discriminatory part and says you can have rules that apply to particular groups, even though men and women, which could be fairly discriminatory. As I've said, he thinks that the rule of law enables us to distinguish liberal from illiberal regulation. He spells out that the rule of law would outlaw, would knock out decisions as to who is to be allowed to provide different services or commodities at what prices and in what quantities. And in other words, measures designed to control the access to different trades. I think he had in a previous thing about certification of professions and occupations, terms of sale and amounts to be produced or sold. All forms of licenses, permits, allocations and price fixing would be impossible since all these methods imply that government has decided who gets what. The same for quota subsidies and tariffs. But then we progress on, read more, and it says, the rule of law, though necessary, is not sufficient for the satisfactory working of a free economy. In the Constitution of Liberty and the law legislation of liberty is two tomes. Hayek introduced two further constraining principles to limit state coercion: expediency and community interest. Expediency I've also already referred to. It's cost-benefit analysis. If there's a case for government intervention, in order to control the government's discretionary actions, we have to do a cost-benefit analysis to decide whether it is liberal, in inverted commas, subject, of course, to non-interference with the market and pricing system. And he says, where the government merely undertakes supply services, otherwise will not be supplied at all. The only question that arises is, do the benefits outweigh the costs? And Hayek says in 1944 already that the state is just a piece of utilitarian machinery. So we've got a combination of his liberalism with utilitarianism. Let's see, 10 minutes. These in 1973 in LLL, he says that the interventions to be determined chiefly by considerations of efficiency and expediency rather than justice satisfy three principles: no monopoly of government, uniform taxation, not used as an instrument of redistribution, and thirdly, satisfy the collective wants of the community as a whole and not merely the collective wants of particular groups. Rule of law, expediency, community interest. What is community interest? Hayek says the ultimate standard is neither the rule of law or expediency, but community interest. In a free society in which power rests on opinion, and now I've lost my place, this ultimate power will be the power which deters nothing directly, yet controls all positive power by tolerating only certain kinds of exercise of that power. This opinion is seen to come from society's common cultural view of what is right and wrong. This posits an uncomfortable position for liberals, because in Hayekian terms, the acceptability of a regulation or state of affairs relies on liberal views being widely held. The implication is that if liberalism is to survive and influence public policy, politicians and the public must hold liberal views. It's the logical outcome of that proposition. Hayek also attached at some stage, I can't really date when, an evolutionary theory. We've already seen the common law, Browne law, the spontaneous order is an evolutionary dynamic thing. And I don't want to say too much about his evolutionary theory of the common law, other than to say that he's approached this as a continental lawyer. If someone was writing about the common law, they'd read a larger number of cases and decide how the common law was being judged. And I think he had a very simplistic view of the common law and how it evolved. And he confused customary law, say Anglo-Saxon customary law, with the common law. The common law was actually heavily influenced by state intervention. The courts were rationalized. They became the monopoly provision of the courts. In the old days, there were numerous courts, ecclesiastical courts, common law courts, and I don't think he properly understood. But you can see why he latched onto it, because the common law does evolve. It's not by central direction. It has open-ended rules, abstract general rules that are applied to specific circumstances. But at a conference I went to at the LSE last month, that the idea that evolutionary process would lead to a liberal state is actually a bit far-fetched. As someone said at the conference, evolution is blind. It doesn't know where it's going. You can have an evolutionary theory of plants, but you haven't got a view in the back of your mind what a plant should look like. But in a liberal framework, you know you have a liberal view and you want it to emerge into a liberal thing. And evolutionary theory can be applied to the state and regulation and statutory law and politics. 6 minutes. I just want to touch on one other area, and this is the current concern about bigness, big pharma, big tech. There's obviously an attack going on now against bigness, which occurred in the 1930s too, with Bernanke and all those guys saying that the market was getting more concentrated. The trust busting is another example, that monopolies were being created by the trusts. Now Hayek, and this goes on to another paper I've written, but during the Mont Pelerin Society meeting, if you read some of the talks by Simons and even Friedman and post-Stiglitz, they are very interventionist in the antitrust terms. They're saying that big corporations have to be broken up, basically. Hayek never accepted that position. But the Chicago School, as it emerged, was heavily influenced by Henry Simons, and his agenda for a liberal economy was quite interventionist, and it was basically an atomistic economy. And Hayek said, one of the unknowns to be discovered by the market process is what is the effective size of a firm, and it's based on technological and economic factors. And you can have a monopoly as long as it's providing goods and cheaply, and there's no alternative out there. Those monopoly profits are an inducement for other competitors to come into the marketplace. And so if you read some of the American literature of Hayekian free market, as they say, Hayek is all about letting things rip and competition. But Hayek was, however, concerned about bigness. And one of the concerns was, well, I list 4 here. One, he was concerned about corporation law. He felt that giving corporations the same rights as legal persons, natural persons, and allowing cross-ownership between corporations assisted the growth of monopoly and pushed the size of enterprises beyond that justified by technological factors. And he said there was a strong case for redesigning corporation law so as to impede the indefinite growth of individual corporations. However, it makes no suggestion about that reform of the corporation law too. And that's a general tendency of Hayek when he gets to the policy issues, that he just backs off and says that's a matter for another lecture. And I know there's a talk on patents. He was against patents too, but that's a matter for another lecture. But he was essentially concerned about the corporate society, corporatism. He said the propensities, the other reasons he was concerned about large corporations is that they can lobby and gain favourable regulation, so a public choice approach was emerging, and this obviously arose out of his observations of the rise of National Socialism and people like that. They can grow too big to fail, eliciting government action. You can see that with the banking system, but also governments constantly stepping in to bolster up firms, and through monetary policy, we've got these zombie companies that wouldn't have existed had it not been for government intervention, and then are said to be the result of the capitalist economy failing. But one of the major concerns he had was that large corporations or organizations insulate individuals from market and entrepreneurial activity, and they breed an anti-market and anti-competitive sentiments, leading to political support for greater government intervention, which would undermine the competitive order and liberalism. So here we have another paradox, potentially. Well, no, it's not potentially. Is that the success of the market and the growth of companies in the market, which he didn't have a theory of other than say it's technological factors. Coase, I think, filled in the gap about why firms arise and how they are compatible with the market system. He didn't make the point of this paradox that the success of the market leads to anti-market, because one of his central propositions is that people don't know how the market works. They sit there adapting to pricing signals. Firms then bring in workers who are paid under an administrative process and are following orders within the firm and not subject to market forces themselves. So that he paints a picture of generalized ignorance about how markets work, even how the economy works. And as a result of that ignorance, the market feeds the information to them. But in terms of their thinking about regulation and government policy, they're affected by the fact that they have very little exposure to market forces. So liberalism has a paradox in it, that the more successful it is, the more likely it comes under attack from the people that it has benefited. And so that is one of the major paradoxes. So what is Hayek's solution? We are sitting in Hayek's solution, which is the battle of ideas. We have to tell the public, in a sense, how good liberalism is. We've got to set up the IEA. That was, Fisher wanted to become an MP, and Hayek said, "Don't bother, set up the IEA." And so we've got to engage in the battle of ideas. And just to end off about how do we control regulation, apart from these paradoxes that I've mentioned, when Hayek outlines, we have to have social security schemes, and again, he's a bit blinded by the fact that he's set out a knowledge problem. How do we know what systems to put in place? The politicians don't know, they won't have the information. And inherently, these schemes are designed in non-market situations where the market does not exist or fails externalities, public goods issues. And he says, well, the regulators have to do cost-benefit analysis. Now, cost-benefit analysis has been used under the Reagan administration and even before then, and it's being constantly used. And anyone who looks at these cost-benefit analysis realizes they're ex-post rationalization for preferred policy, not critical analysis of what is the best policy. So I'll end on that note. It's a bit pessimistic, but keep on the good work. I think it's